The Second Amendment doesn't ask for permission, but California just decided you should. Starting January 1st, 2026, Senate Bill 948 fundamentally reshapes how Californians exercise their constitutional right to keep and bear arms. This isn't about background checks or waiting periods we've debated for decades. This is about requiring law-abiding citizens to obtain government approval before every single firearm and ammunition purchase through a mandatory firearm purchaser license system. Think of it as a permission slip, one that costs money, requires your time, demands your personal information, and can be denied or delayed at bureaucratic discretion. Now, supporters argue this creates a more streamlined process and enhances public safety by ensuring buyers meet all legal requirements up front. Critics see something entirely different, a constitutional right now conditioned on bureaucratic approval, where exercising your Second Amendment freedom first requires asking the state, "Mother, may I?" This isn't just California policy anymore. It's a blueprint being watched nationwide. Whether you're pro-gun, anti-gun, or somewhere in between, SB 948 represents a seismic shift in how Americans might access firearms in the future. And what happens in California rarely stays in California. Let me be completely transparent with you about what's actually happening here, because the details matter and the devil is absolutely in those details. California Senate Bill 948 didn't just appear out of nowhere on January 1st, 2026. This legislation has been in the works, debated, amended, and ultimately signed into law as part of a broader effort by California lawmakers to what they call modernize the state's firearm regulations. But modernize is such an interesting word choice, isn't it? Because what we're really talking about is fundamentally altering the transactional nature of how a constitutional right is exercised. And I want you to understand this not from a place of hysteria or hyperbole, but from a place of genuine analysis of what this law actually does, how it functions, and why it matters far beyond California's borders. So let's start with the mechanics, because if you don't understand how this system works, you can't possibly evaluate whether it's reasonable or not. Under SB 948, California has created what's called a firearm purchaser license, or FPL for short. Now, if you want to purchase any firearm or ammunition in California after January 1st, 2026, you must first obtain this license. Not a suggestion, not a recommendation, but a legal requirement. You walk into a gun store without this license and the transaction simply cannot proceed. The license itself requires you to submit an application to the California Department of Justice, which includes your personal information, your fingerprints, and payment of associated fees. You're also required to complete a firearm safety course that's been approved by the state, pass a written test demonstrating your knowledge of firearm safety and California gun laws, and then wait while the DOJ conducts what they describe as a comprehensive background check. Now, proponents of this system will tell you this is actually more efficient than the current system. They'll say, look, you're going to get a background check anyway every time you buy a gun, so why not do it once? Get it out of the way, and then your subsequent purchases will be smoother and faster. On paper, that sounds almost reasonable, doesn't it? You do the hard work up front, you prove you're a law-abiding citizen, you get your license, and then buying firearms becomes easier, except that's not quite how constitutional rights are supposed to work in America. We don't require people to get a license to exercise their First Amendment rights. You don't need government permission to speak, to worship, to assemble, or to petition your government for redress of grievances. You don't need a license to invoke your Fifth Amendment right against self-incrimination or your Sixth Amendment right to counsel. These are inherent rights that the government is prohibited from infringing upon without due process and compelling justification. But here's where it gets really interesting from a legal and philosophical standpoint. The Second Amendment says the right of the people to keep and bear arms shall not be infringed. May not be significantly burdened or should be reasonably regulated, but shall not be infringed. Now, I'm not a constitutional absolutist who believes that means zero regulation is permissible. Reasonable people can disagree about what constitutes a permissible regulation versus an impermissible infringement. infringement. Background checks to prevent felons and domestic abusers from purchasing firearms. Most Americans, including most gun owners, support that concept. Age restrictions. Again, there's broad consensus that we don't hand firearms to 10-year-olds for purchase, but requiring a license with fees, mandatory training, testing, fingerprinting, and government approval before you can exercise the right at all? That's categorically different, and that's where the constitutional tension becomes impossible to ignore. Think about this through a different lens for a moment. Imagine if California passed a law requiring you to obtain a free speech license before you could publish anything online, speak at a public gathering, or write a letter to your newspaper. You'd have to take a government-approved course on responsible speech, pass a test demonstrating you understand defamation law and incitement standards, submit your fingerprints, pay a fee, and wait for the state to approve your application. Even if the government promised they'd only deny licenses to people who'd previously been convicted of incitement or criminal threats, would you feel comfortable with that system? Would you trust that such a system wouldn't have a chilling effect on speech? Would you worry that the government might slow walk approvals for people whose political views they disagreed with, or that the mere existence of the licensing requirement would discourage some people from speaking at all? Of course you would, because requiring permission to exercise a constitutional right is fundamentally different from regulating the time, place, and manner of that exercise. And here's the thing that keeps me up at night about systems like this. They create discretionary gatekeeping where none previously existed. Under the old California system, if you walked into a gun store, the dealer would initiate a background check through the state's database and the FBI's National Instant Criminal Background Check system. If you passed, the transaction proceeded. If you didn't pass because you were a prohibited person, the transaction was denied. It was binary, and it was based on objective criteria established by law. You're either a felon or you're not. You're either subject to a domestic violence restraining order or you're not. You've either been adjudicated mentally incompetent or you haven't. But with a licensing system, you've now inserted a bureaucratic layer that has the power to delay, deny, or condition approval on criteria that may not be clearly defined or objectively measurable. Now, California officials will insist that the licensing criteria are clearly defined and that denials can only occur for specific legal reasons. And maybe that's true on paper, but anyone who's ever dealt with any government bureaucracy knows that there's a world of difference between what the law says on paper and how it's actually implemented by the people processing applications. Processing times can vary wildly. Application requirements can be interpreted differently by different officials. Appeals processes can be slow and expensive. And for ordinary citizens who just want to exercise their constitutional rights, these bureaucratic hurdles aren't just inconveniences, they're barriers that make the right less accessible, more expensive, and more contingent on government approval than it ever was before. Let me give you a concrete example of how this plays out in practice. Let's say you're a single mother living in a high-crime neighborhood in Sacramento. You've never owned a gun before, but there's been a series of break-ins on your street, and you're genuinely concerned about your safety and the safety of your children. You decide you want to purchase a firearm for home protection. Under the old system, you'd go to a gun store, pick out a suitable firearm, fill out the federal form, submit to a background check, wait the mandatory California cooling-off period, and assuming you pass the check, you'd pick up your firearm. Total timeline, maybe 10 to 15 days, depending on how quickly the background check processed. Under SB948, that same woman now has to first figure out that she needs this firearm purchaser license. She has to find a state-approved safety course, which may or may not be offered conveniently near where she lives or at times that work with her schedule. She has to pay for that course out of pocket. She has to take time off work to attend. She has to study for and pass the written test. Then she has to submit her application to the DOJ with her fingerprints and pay the application fee, which is money she might not easily have. Then she waits. How long? Well, the law says the DOJ has a certain time frame to process applications, but what happens if they're backlogged? What happens if there's some minor discrepancy in her application that requires additional review? What happens if the DOJ is understaffed and processing times stretch from weeks to months? That woman who had an immediate safety concern now has to wait an indefinite period for government permission before she can even begin the process of purchasing a firearm. And during that waiting period, is she safer or less safe? This is not a hypothetical concern. We've seen this exact pattern play out in other states and jurisdictions that have implemented licensing systems for firearms. In New York, for example, the process of obtaining a pistol permit in New York City has historically taken months and sometimes over a year, with applicants facing interviews, extensive background investigations, and significant fees. In New Jersey, the firearms purchaser identification card system has been criticized for processing delays and inconsistent application of standards across different municipalities. These aren't anti-gun talking points. These are documented experiences of law-abiding citizens trying to navigate bureaucratic systems that place significant obstacles between them and their constitutional rights. And now California has decided to implement its own version of this system statewide. But let's talk about the other side of this argument, because I genuinely want to be fair here. Supporters of SB 948 make several points that deserve serious consideration. First, they argue that consolidating the background check process into a single licensing system actually reduces the burden on gun dealers and streamlines subsequent purchases. Once you have your FPL, buying additional firearms becomes quicker because you've already been vetted. There's some logic to that. Second, they argue that the mandatory safety training component will reduce accidents and ensure that gun owners have at least a baseline level of competence with firearms. Given that we require training and licensing for operating a motor vehicle, is it really unreasonable to require training for operating a firearm? Third, they point to data from other states suggesting that licensing systems may reduce certain types of gun violence, particularly impulsive purchases by individuals in crisis. If this system saves lives, they ask, isn't that worth some additional inconvenience? These are serious arguments, and they deserve serious responses. On the efficiency point, I'd say that any efficiency gained for subsequent purchases doesn't outweigh the massive upfront burden placed on first-time buyers. You've essentially created a two-tiered system where people who already own guns and already have their licenses face fewer barriers than people who don't, which seems backwards if your goal is public safety. On the safety training point, I'd note that the vast majority of gun owners already seek out training voluntarily because they understand the responsibility that comes with firearm ownership. Mandating training might catch some marginal cases, but it also turns what should be a best practice into a government requirement backed by criminal penalties. And on the public safety data, I'd say that correlation doesn't prove causation, and we need to be very careful about implementing policies that restrict constitutional rights based on statistical analyses that may not account for all relevant variables. Moreover, there's a fundamental principle at stake here that goes beyond empirical debates about effectiveness. In a free society, the default position should be that citizens have their rights unless and until they've done something to forfeit those rights through their own actions. The burden should be on the government to prove that someone is prohibited from owning a firearm, not on the citizen to prove that they deserve permission to exercise their rights. Licensing systems flip that presumption on its head. They start from the position that you don't have the right to purchase a firearm unless and until the government grants you permission. That's a fundamental reordering of the relationship between citizen and state, and it's one that should concern anyone who cares about civil liberties, regardless of how they feel about guns specifically. And this brings us to the broader question that I think is really at the heart of this debate. What is the proper role of government in regulating access to firearms in a society that values both public safety and individual liberty? This is not an easy question, and anyone who tells you it is probably hasn't thought about it deeply enough. On one hand, we have a constitutional right that's explicitly protected in our founding document. On the other hand, we have a genuine problem with gun violence in this country that manifests in multiple forms, from mass shootings to suicides to everyday street crime. Finding the right balance between protecting rights and protecting lives is genuinely difficult, and people of good faith can disagree about where exactly that line should be drawn. But here's what I keep coming back to. The solution to violence and crime is not to make it harder for law-abiding people to protect themselves. It's to enforce existing laws against criminals, to address the social and economic conditions that drive violence, to improve mental health services, and to build communities where people don't feel they need to resort to violence to resolve disputes or achieve their goals. Creating new bureaucratic hoops for legal gun purchasers to jump through doesn't disarm criminals. It doesn't stop illegal gun trafficking. It doesn't address the root causes of violence. What it does is make it more difficult, more expensive, and more time-consuming for ordinary citizens to exercise their constitutional rights. And if we're being honest, it disproportionately affects the people who can least afford those additional burdens. Working class folks, minorities, women, and people living in the communities most affected by crime. There's also the question of precedent and the slippery slope, which I know some people roll their eyes at, but I think it's genuinely relevant here. If California can require a license for firearm purchases, what's to stop them from requiring renewal of that license every year with additional fees and training requirements? What's to stop them from adding discretionary criteria that allow officials to deny licenses based on subjective judgments about an applicant's suitability or good moral character? What's to stop them from imposing waiting periods for license applications on top of the existing waiting periods for firearm purchases? Once you've established the principle that government permission is required to exercise a constitutional right, you've opened the door to virtually unlimited regulation, because the question is no longer whether regulation is permissible, but merely what degree of regulation is permissible. And that's a much more difficult question to answer with any principled limiting standard. Looking at this from a national perspective, California's adoption of SB 948 matters because California is often a testing ground for policies that later spread to other progressive states and sometimes become models for federal legislation. We've seen this pattern with environmental regulations, consumer protection laws, and yes, gun control measures. What starts in Sacramento doesn't stay in Sacramento. It moves to Albany, to Olympia, to Trenton, to Boston, and before you know it, you have a patchwork of different licensing requirements across different states, making it virtually impossible for a law-abiding gun owner to travel with their firearm or understand what's legal and what's not as they cross state lines. This is why the Second Amendment community watches California so closely, because they understand that today's California law is tomorrow's national debate. And we need to talk about enforcement, because that's where rubber meets road with any law. How exactly is California going to enforce SB 948? What happens to someone who attempts to purchase a firearm without the required license? Presumably that's a criminal offense now. What happens to a gun dealer who sells to someone without verifying their license? Presumably they face penalties, maybe loss of their federal firearms license. But what about private transfers? What about gifts between family members? What about temporary loans at a shooting range? The law undoubtedly addresses these scenarios, but the point is that you've now criminalized a whole range of conduct that previously wasn't criminal, and you've created new opportunities for people to inadvertently violate the law and face serious consequences. This is the reality of gun control in America in 2026. We're not having a national conversation about how to actually reduce violence. We're having 50 different state-level conversations about how to regulate the exercise of a constitutional right, with each state implementing its own system based on its own political preferences. Some states are moving toward permitless carry and fewer restrictions on gun ownership. Other states like California are moving toward comprehensive licensing, registration, and permission-based systems. And the result is a country where your Second Amendment rights depend almost entirely on your zip code, which seems fundamentally at odds with the concept of constitutional rights that are supposed to be protected nationwide. So where does this leave us? California's SB 948 is now the law of the land in the nation's most populous state. Millions of Californians will now have to navigate this new system if they want to purchase firearms or ammunition. Some will comply, jumping through all the hoops and obtaining their licenses. Some will be deterred entirely, deciding it's not worth the hassle or expense. Some will challenge the law in court, arguing it violates the Second Amendment. And some, inevitably, will simply ignore it, either out of ignorance or defiance, creating a new class of technical criminals who pose no actual threat to public safety, but who have violated California's increasingly complex web of gun regulations. The courts will ultimately decide whether SB 948 passes constitutional muster, but that process will take years and will depend heavily on how judges interpret recent Supreme Court precedents on the Second Amendment. In the meantime, this is the reality for gun owners and prospective gun owners in California. And for the rest of America, this is a preview of what gun regulation might look like if the California model spreads. Whether you think that's a good thing or a catastrophe probably depends on your underlying views about guns, rights, and the role of government. But regardless of where you stand, I think we can all agree that this represents a significant shift in how Americans access firearms, and it's a shift that deserves our attention, our scrutiny, and our serious consideration of whether this is the kind of country we want to live in.